Friends, in this video I am going to deal with the constitutional position of the President of India. In the next video, I shall deal separately with his powers and functions. The framers of the Indian Constitution have adopted Westminster form of executive and legislature with some modifications. Thus, the Constitution provides for a parliamentary form of government where the executive is responsible to the parliament. It also provides that the president shall be indirectly elected, which is a clear departure from the British model, where there is a hereditary monarch as the formal head of the state. The Indian president is elected indirectly. The framers of the constitution considered the question whether the president should be elected directly by the people or not. Finally, they chose to have indirect elective procedure as the executive power resides in the ministry. The real executive power resides in the ministry and not in the president. Now, let us consider who can contest the election for the president's office and what are the qualifications he should possess. Article 58 provides that in order to be eligible for election to the office of the president, one has to be a citizen of India and should have completed the age of 35 years and should be qualified to be a member of Lok Sabha. This means one should not be of unsound mind and an undischarged insolvent. The president cannot hold any office of profit under the government of India, a state, government or any local body. However, an incumbent president, vice president, governor or a minister is eligible to contest the election. If a member of parliament or a state legislature is elected as a president, on assuming office, he will be deemed to have vacated that membership according to Article 59. The framers did not want the president to be elected only by the members of the parliament, as that would have been a narrow basis, and as the parliament being dominated by the ruling party would have chosen a candidate from that party. Hence, the members of state legislative assemblies have also been included in the electoral college. However, the nominated members of the houses of the parliament do not have any voting rights. The election is held in accordance with the system of proportional representation by means of a single transferable vote. The voting is by secret ballot. Article 55(1) provides that as far as practicable there shall be uniformity in the scale of representation among the states inter se, as well as parity between the states as a whole and the union at the election of the president. The value of votes of members of parliament and state legislatures is almost equalized by adopting a formula. According to the formula, each elected member's votes is obtained by dividing the population of the state by total number of elected members' votes. The quotient obtained is multiplied then by 1000, which gives the number of votes of each member of a state legislative assembly. Number of votes of each member of parliament is obtained by dividing the total number of votes of legislative assemblies of all states by number of members of both houses of parliament. Before entering upon his office, the president-elect has to subscribe to an oath of affirmation in the prescribed form in the presence of the Chief Justice of India. The president cannot be a member of a house of parliament or a state legislature. The president is elected for a term of 5 years and he is eligible for re-election. The office may fall vacant in the middle of the term because of death, removal, resignation, or because the election may be declared void due to some infirmity in the process. When such a casual vacancy occurs, the Vice President discharges the functions of the office of the President. Article 62 provides that on the expiry of the term, election to choose the next president shall be completed before the expiry of the term. When vacancy occurs due to death, resignation, or removal, the election shall be held as soon as possible but not later than 6 months from the date of vacancy. The President is entitled to use his official residence free of charge. He is also entitled to such emoluments and allowances as may be determined by the Parliament by law. Under Article 71, the Supreme Court has been given exclusive jurisdiction to decide disputes relating to the election of the President, and Parliament has been given the power to regulate by law other matters relating to elections. In excess of this power, Parliament has passed the Presidential and Vice Presidential Election Act of 1952. Section 18 of the said Act provides that only such infirmities in the election shall be the cause for complaint which can be said to have materially affected the result of election. To discourage light-minded persons from contesting elections, the Act provides that the name of presidential candidate must be proposed by 50 electors and seconded by 20 electors. In N.B. Kare versus Election Commission of India, a case decided in 1957 by the Supreme Court, a petition was filed demanding the postponement of the presidential election on the ground that there is vacancy in the electoral college, as a general election was not held in parts of Punjab and Haryana. It was held that an election petition can be filed only after the election process has been completed, and relief from the court cannot be claimed to stop the process of election. Later, the 11th Amendment to the Constitution, passed in 1961, inserted Clause 4 to Article 71, which provides that the election of the President or Vice President shall not be called in question on the ground of existence of any vacancy for whatever reason among the members of the Electoral College electing him. Under the Presidential and Vice Presidential Elections Act of 1952, it is provided that the election of the President can be challenged only by a candidate or 10 or more electors. If his election is declared void by the Supreme Court, acts done by him in excess of his powers before the date of decision of the Supreme Court will be valid. The Constitution also provides for removal of the President by impeachment under Article 61, which is a complicated process. Firstly, he can be removed only on the charge of violation of the Constitution. The charges of commission of crimes, bribery, and corruption would be covered. Under Article 361, the President is given immunity against being prosecuted on a criminal charge or being imprisoned during the term of his office. But on the same charges, he can be impeached and a formal prosecution can follow after his removal. Secondly, the charge may be preferred by either house of the Parliament. It has to be moved in the form of a resolution after at least 14 days notice has been given of the same, signed by at least 1/4 of the total number of members of that house. Thereafter, it has to be passed by that house by 2/3 majority of the total membership of that house. Thirdly, thereafter, the charge is transmitted to the other house. The other house has to investigate the charge or to get it investigated by any committee or tribunal or even by a court. The President has the right to appear and to be represented at such investigation. If after this the House passes a resolution by a majority of not less than 2/3 majority vote of the total membership of that House that the charge has been proved, such a resolution has the effect of removing the President from his office from that moment. In India, so far, no President has been removed from his office by impeachment. With this, I conclude this first part, and in the second part, as I have already told you, I shall deal with his powers and functions. That is actually in a separate video. I request those of you for listening to this lecture, and who have not subscribed to this channel, to subscribe to the channel. It is free and get notification whenever a new video is uploaded. My objective in this academic exercise is only to provide genuine lectures which the students can trust. So with this I conclude. Thank you.